welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case with Richard Allen, Indiana versus Richard Allen, and justice for Libby and Abby. We've got their pictures here, and they kind of have been lost in the shuffle. If you've been paying attention to what's been going on at all, it's all this smoke show going on with Judge Gull and the prosecutor and the defense attorneys and trying to get them kicked off, and it just extended the whole trial and everything. So it's kind of been a crazy thing to watch, and it's definitely unprecedented. So, without further ado, we're going to continue talking about and reading the court documents. I compiled the ones from last week, so that's what this is. I'm recording here today, March 11th, and this is for the week prior. Excuse me. Tickle in my throat. Sorry. No, you guys don't want me to cough in your ears. All right, so we're going to talk about Rick Allen's mental health records, how the state wants them. We're going to talk about some legal jargon. We're going to learn some terms and read through a bunch of these different filings that we have. So let's get started here. Before we get started, please hit that like button. I often forget to ask you, but it really helps out my channel and it helps out your algorithms as well. It lets YouTube know what kind of videos you like and what kind of topics you're interested in. So they'll show you more Delphi videos if that's a topic that you're really interested in. All right, so, whoops, I went the wrong way. All right, so motion for leave of court to subpoena third-party records. This is the first motion we're going to read, and it's interesting. So this is from the prosecutor, and he is asking for the court to subpoena Richard Allen's mental health records, basically, from the entire time he's been incarcerated. So this was filed just last week, last Wednesday, the 3rd of March. And here we go. Comes now the state of Indiana by Nicholas C. McLeland, prosecuting attorney for the 74th Judicial Circuit, and moves this court for an order for Westville Correctional Facility and Wabash Valley Correctional Facility and any and all mental health records for Richard Allen associated with his stay as an inmate in the Department of Corrections from November 3rd, 2022 until present. So this next part we're going to totally skip over. It is the probable cause affidavit or language from it. I don't want to read through it all. It's very lengthy. Here we're actually going to skip now down to page 10 because we're not going to read through it. So based on everything that I just skipped, if you do want me to read the probable cause affidavit, if you haven't read it or you want another look at it, you want to refresh your memory, let me know in the comments below, and I will be happy to read through the probable cause affidavit for the Delphi case as to what led investigators to their probable cause to arrest Richard Allen. All right, so anyways, based on the probable cause charges, the defendant has been held in the Carroll County Jail, transferred to the White County Jail, and then ultimately transferred to Westville Correctional Facility and is currently housed in Wabash Valley Correctional Facility. He has been held in the Department of Corrections since November 3rd, 2022. During the defendant's time in incarceration, the defense has filed several motions that have called into question Richard Allen's mental health and his physical well-being because of the alleged conditions at Westville Correctional Facility and Wabash Correctional Facility. The motions include an emergency motion to modify the safekeeping order filed on April 5th, 2023, where the defense writes that Richard Allen should be moved because of his deteriorating condition. They reiterated this point several times in the hearing on the motion to modify the safekeeping order. Then again in the defense's motion for order on continued disclosure of the defendant's mental health records filed on June 7th, 2023, where the defense writes that they need his mental health and medical records because of his currently deteriorating state, both mentally and physically. Then again, in their memorandum in support of the accused's motion for Frank's hearing, which we've read through in this channel, filed September 18th, 2023, where the defense writes that on April 3rd, 2023, Richard Allen's mental health began a steep decline. The defense has expressed concerns that Richard Allen is being treated unfairly or is being placed in conditions that resemble, quote, a prisoner of war. Which I actually am not sure if it was these current attorneys, Andrew Baldwin and Bradley Rosie. I'm not sure if it was them or if it was the other attorneys, Skremlin and Libreto, that were on the case that were trying to have him moved because they also saw signs of odinism and unfair treatment to this one particular client or inmate, So I do actually think it was the other attorneys, but it might be these attorneys, I'm not sure. Anyways, the Libreto and Scrumman did say that it felt like going to see Hannibal Lecter or something, and they were treating him like Hannibal Lecter. So they even quoted that in their one of their motions to get him moved, transferred to another prison. All right, so the state has filed a motion for leave in the past to obtain these records, and the defense objected to said motions, and rightfully so. You don't need his mental health records. The defense has now filed a verified ex parte motion for hearing on funding for defense for expert services. So hold that thought on ex parte. We'll talk a little bit about it in a minute, but ex parte means like one party. So just keep that in mind. All right, so within that motion, the defense asked the court to approve funding for Dr. Polly Westcott, a clinical psychologist, and for a confession expert. The defense states the conclusion to be drawn from this is that there is a reasonable basis upon which to incur into the impact of the accused's confinement on his mental state. This can only be done by an expert in the field of the impacts of solitary confinement on accused individuals. It is clear from this statement and other affirmations made in the motion that the defense intends, so he quotes their motion, their ex parte motion. It is clear from this statement and the other affirmations made in the motion that the defense intends to challenge the multiple confessions that the defendant has made while incarcerated. Further, it is clear that the defense intends to make the defendant's mental health an issue in this matter. In order to address this, the state needs to review the defendant's mental health records and have an opportunity to consult its own expert. The state concedes that the defense has not filed any kind of insanity defense or any other defense on behalf of Richard Allen, but their repeated allegations have made the defendant's mental health an issue. I have a feeling they just want to hear what Richard Allen is telling them. I think they're just trying to intercept any messages that might be talking of corruption or anything of odinism or anything of being framed, whatever. So the defense has now brought Richard Allen's mental health into question again in their most recent filing when they requested funds for an expert. For these reasons, the state is requesting the mental records, I think they meant mental health records, for Richard Allen from Westville Correctional Facility and Wabash Valley Correctional Facility since his stay the beginning in November 2022 to the present as specified in the attached subpoena duces tecum and or request for production of documents and records to a non-party. The request is made for the purpose of preparing for trial. In this matter, the state believes that Richard Allen's mental health is going to be argued at trial. Well, you can't just You can't just want it because you think that the other side is going to use that. And they haven't put that in as their, you admitted in your filing that they're not using it, his mental health as a defense. Yeah. These prosecutors, man, the more I'm digging into these cases, the more I'm realizing there is so much corruption going on in these towns, especially like these small towns like Delphi, Canton, Massachusetts. Well, I don't know how small that is, but I think it's a little bigger, but still, there's a lot of corruption going on in these towns. The state believes this request is made for the purpose of preparing for trial. The state believes that Richard Allen's mental health is going to be argued. The state believes that the mental health records of Richard Allen would be able to confirm or deny the information that the defense has alleged in its filings. The state is not asking for an entire mental health history of Richard Allen, but only those records for his stay at the Westville Correctional Facility and Wabash Valley Correctional Facility from the 3rd of November 2022 until the present, to be able to respond to the allegations made by the defense and to prepare for trial. The state of Indiana is aware from prior filings that the defense objects to the subpoena. The state of Indiana has also sent them a courtesy copy of the subpoena via email. What a bunch of mother effers. Therefore, the state of Indiana, Nick McClellan, prosecuting attorney, respectfully prays that the court review the attached subpoena and then order production of said records and such other relief as it is just and proper in the premises. So that was signed by Nicholas McClellan. Where's my ex parte? I know I have an ex parte slide. It must be later on. Basically, ex parte means for one party. So when you're giving it to the judge, it means like this is not for the other party's eyes. But basically, he read a file that should have been confidential to him. It was not for his eyes to see, and he quoted from it. The where was it? It was after that. Oh, I keep skipping it, I think. This here. Where does it start? The conclusion to be drawn. This is where the defense states, the conclusion to be drawn from this is that there is a reasonable basis upon which to inquire into the impact of the accused's confinement on his mental health or mental state. So they are quoting specifically from a motion that they were never, ever supposed to see. So there's that. And I thought I had my definition here, but I guess I don't. Sorry. Actually, hold on one second. I try to make this slightly smaller just to fit the screen better. I feel like it's cutting off the bottom. Okay. Anyway, so subpoena. What does subpoena mean? What the Latin meaning of subpoena means under pain or subject to penalties. So that is the literal meaning of subpoena, under pain or subject to penalties. So if you do not show up to court, the subpoena says, I will throw you in jail. That's your penalty, under pain or penalty. All right, so duces tecum in Latin actually means to bring with you. So a subpoena duces tecum means you must bring with you under pain or subject to penalty. So if you don't bring this document, you could face fines or whatever the penalty may be. So a court summons requiring the recipient to not only appear before the court, but to bring specified documents, evidence, materials, or other tangible evidence in connection to a case or lawsuit. So this is anything. It could be anything. It could be a flash drive. It could be a hard copy of a specific photo, or who knows, whatever. So whatever it is that the court is asking you to bring, you must bring, or else you could go to jail, you could get a fine, whatever the court deems necessary. All right, so this is the subpoena ducis tecum uh, from Nick McClelland to the Westville Correctional Facility, pursuant to Rule 2 of the Indiana Trial Rules of Trial of Criminal Procedure, request that the following documents and records be produced for the Carroll County Prosecuting Attorney Nicholas C. McClelland within 30 days from the date of service of this request for production of documents and records to a non-party. You may comply by mailing a copy of the requested documents to the prosecutor's office postmarked prior to the date on which production is required by the Indiana Rules of Trial Procedure. Definitions. As used in this request, the term document encompasses the full scope of that term as it is used in Trial Rule 34, including without limitations all writings, papers, photographs, videos, and other recordings and communications of any kind, whether printed, electronically recorded, filmed, or recorded, or produced manually or by the other process. So basically, it's a blanket statement for every and everything, any and everything, pretty much. The term document includes, all margin, comments, handwritten notes, date of receipt stamps, and notations of any kind appearing on any document. The term document includes all fields and data stored on computer disks or hard drives, all files and data stored on any computer databases. So if you weren't sure, it should be covered in here. It's a very, very long definition of what a document could be. So for each document produced, identify the corresponding request. If you claim any information sought herein is privileged in whole or in part, object to any form of any request, or believe that any document would be excluded from production to the state regardless of its relevance, state the reasons for said objection or ground of exclusion. Identify with particularity each document for which you claim a privilege, including the date of the document, the person who prepared the document, the person to whom the document was directed, the substance of the document, and the reason you believe the document is privileged. So all those reasons. Instructions. This request for production of documents and records to a non-party is made pursuant to Rule 2 of the Indiana Rules of Criminal Procedure. In accordance with that rule, 1. You are entitled to reimbursement for costs resulting from your response to this request. So, like if it cost me $30 to overnight it to you or whatever, you could pay me back. If there are costs associated with production of these documents, please let me know. So if it's like 5 cents a page, also put that on my tab. You are entitled to security against damages or repayment of damages which may result from this request, and you may respond to this request for production of documents to a non-party by submitting to its terms. Or by proposing different terms, or by objecting specifically or generally to the request by serving a written response to the prosecuting attorney, Nicholas McClelland, within 30 days from receipt. Whoops, I keep doing that, or it just goes on to the next page. Hold on. Where was I? So they need to respond to Nick McClelland within 30 days from the receipt of the request for production of documents and records to a non-party, or by moving to quash this request for production of documents and records to a non-party, or permitted by Rule 2 of the Indiana Rules of Criminal Procedure. Number 3, the failure to respond to this request for production of documents and records to a non-party, to object to it, or to move to quash it, as provided by the applicable Indiana Rules of Criminal Procedure or order of the court within 30 days from the date of service, will subject you to a motion for sanctions pursuant to Rule 2. So you're going to be sanctioned if you don't respond to this request. You are required to keep the subpoena and the information contained therein confidential. The subpoena and the information listed herein is not to be released to the public and should be kept confidential. Any release of this information will be a direct violation of a court order. Documents and records to be produced. Here we go. Any mental health records that you may have concerning Richard M. Allen, including all records from any physician that has evaluated or examined Richard M. Allen from the beginning of his stay at Westville Correctional Facility and Wabash Valley Correctional Facility. And this is probably why Richard Allen probably didn't tell any of his physicians anything, because he probably figured that his stuff was going to be subpoenaed. He probably didn't talk much. If I'm assuming, if he was scared that this was a widespread corruption that was affecting him being in prison, you probably wouldn't want to talk to anybody about it, because you wouldn't know who you could trust. Anyways, the results of any mental health evaluation and or exams performed on Richard Allen while he has been incarcerated at either facility, any other documents, records, notes, videos, and or writings that the facility may have pertaining to Richard Allen mental health during this time of incarceration at both facilities submitted under my hand as counsel of record. Nicholas McClelland. And we have a subpoena for Westville Correctional and one for, what was the other one? Isn't this Westville Correctional and Wabash? Okay. So then this is probably, oh, this is just another document saying, pursuant to Rule 2 of the Indiana Rules of Criminal Procedure, you are hereby directed to produce the following. So it's just continued on. So all document requested in the accompanying request for production of documents and any executed affidavit of custodian of or records. Okay. Again, that was March 6th. So here's an affidavit of custodian of records that they provide in for their own ease, convenience to do this. So they could just put, I state your own name on behalf of Westville Correctional Facility, swear that these records are accurate, basically is what they want there. So then the next motion that we have is the verified motion to extend so sorry, that was the end of that, and we're moving on to this. I kind of didn't transition very nicely there. So that was pretty much the end of that. They ask for the records, and basically they're asking the court to issue a subpoena for that. So here is the verified motion to extend the discovery deadline. This is coming from the defense. They want to extend the discovery deadline for the contempt hearing. The defense's attorneys. It should actually be a separate case, but they filed it incorrectly. And the judge said, I don't care, we're going forward with our hearing anyways. So the next day, Thursday of last week, this document came out. Comes now counsel for attorneys Baldwin and Rosie, and respectfully move to extend the discovery deadline on March 7th in support thereof. Counsel states on February 22nd, 2004, the court issued an order stating in pertinent part, quote, now orders counsel for the defense attorneys to provide to the state of Indiana all the exhibits intended to be introduced at the March hearing. So that must be 2024. That really did confuse me. So that's 2024. Okay. That's an error there. All right. So the defense now orders counsel for the defense attorneys to provide the state of Indiana all the exhibits intended to be introduced at the hearing on March 18th, 2024, on or before March 7th, 2024. The court did not issue a reciprocal order for the state to provide their exhibits expected to be introduced. Like, yeah, Judge Gull, be fair. But she's not. She's not being fair at all. All right, so, however, Mr. McClelland and undersigned have cooperated in reciprocal discovery. Undersigned has provided expected exhibits to Mr. McClelland as they have become available. The undersigned believes Mr. McClelland has provided all expected exhibits available to him prior to March 1st. On March 1st, 2024, counsel conducted depositions of most of the state's identified witnesses. At that time, it was learned that the ISP report provided to Mr. McClelland, then the undersigned, did not contain the attachments. Mr. McClelland pledged to obtain them and share. Also, during the depositions, it was learned that Sergeant Holman had conducted recorded interviews with pertinent people. Please stop doing that. It skips without me. It skips to the next page. It's frustrating me. Again, Mr. McClelland assured the undersigned they would be produced. So there are documents that have not been produced yet, like these depositions of Sergeant Holman. With these people. I don't know. So what do you guys think about that? There are still some documents. So they're saying that they're sharing documents. They're sharing discovery, but they're also saying, wait, but there's still discovery that we don't have. On March 5th, 2024, at 8:24 a.m., Mr. McClelland communicated to undersigned that he had the attachments and would collect the interviews and provide them through discovery that day. Then, on March 6th, at 9:23 p.m., Mr. McClelland advised that due to time constraints, he would be unable to provide those materials until March 7th. Upon review of the state's additional discovery, the undersigned may have additional exhibits. It will be impossible to determine that until the new materials are reviewed, which, due to counsel's schedule, cannot be done before late in the afternoon of March 7th, 2024. On February 29th, 2024 and March 1st, 2024, the defense was contacted by two separate individuals who claimed to have documents pertinent to links to those photo leaks of the crime scene. Despite diligent efforts, the defense has not yet obtained these documents to be able to assess their credibility and reliability. Upon doing so, the defense may have additional exhibits, which of course will be provided to the state as all others have been. Time is certainly not of the essence because everything the state complains of happened months ago and was fully vetted. The state did not file its allegations of contemptible conduct until after the Indiana Supreme Court reinstated attorneys Baldwin and Rosie. The issue of contempt is not an urgent matter. Mr. McClelland objects to an extension, because he's a nitwit. Undersigned requests an extension of 1 week. David Hennessy, the attorney for Baldwin and Rosie. So that was that. What do you guys think? Think they're delaying? I mean, they've been delaying other discovery, so why not that? And they've been playing games with the discovery, so whoops. Here is the next document we're going to look at. It was filed on the 7th of March also. This is the list of additional witnesses and exhibits for contempt hearings. So, as promised, because they are forced to, here's a list of exhibits and witnesses. All right, comes now counsel for Attorney Baldwin and Rosie and notifies the state and the court that in addition to all witnesses and exhibits previously disclosed, he may call the following witnesses and offer the described exhibits. Do you have to go potty? I gotta take the guy's potty. Hold on 1 second here. We're still having pancreatitis issues, so with the dog. So we've got lots of potty breaks. Hi everyone. Sorry, I'm back. I'm gonna have to get up and take them, grab them again, bringing them in. But I just didn't want to leave you guys the whole time. So here we are. A list. I'm downstairs and like right at the door, so I can just rush and go to the door. We're having my German Shepherd named Dexter after Dexter Morgan on the TV show. Um, he's got pancreatitis issues, and so he has trouble digesting stuff, and yeah, we got bathroom problems. It's not fun. So sorry about that, and I'm trying hard to still record and keep up on these things, and it's hard when he's asking to go out. So I apologize. Anyway, so comes now counsel for Baldwin and Rosie and notifies the state and the court that in addition to all witnesses and exhibits previously disclosed, he may call the following witnesses and offer the described exhibits. So witnesses could be Stephen Wood, Angela Sadlowski, Julie Melvin, Terry Williams, Courtney Parsons, and Matt Hoffman. Exhibits 1. Communications between Gary Baudet, a.k.a. Fig, a.k.a. Figzolf, I don't know, and Prosecutor McLeland. Multiple. I don't know what that means. So these are exhibits between them. Communications from Baudet about Prosecutor McLeland. Anthony Greeno's YouTube episode titled Crime Nation, Delphi Unalivings, Watch and Review. I might have to take a look at that. Rick Snay on True Crime Investigates, and Baldwin email to McLeland regarding Professor Turco report, Baudet's communications with Angela Sadowski, Baudet's YouTube episode regarding the Delphi investigation. Who is Baudet? Gary Baudet. I'm going to have to look that up. All right, it might be, it must be, well, Greeno. There's Anthony Greeno, who's a YouTube creator, and then there's also this Gary Baudet, aka Fig, aka Figzolf. All right, so Baudet's communications regarding court staff revelations, Baudet's communication regarding disqualification of defense counsel, so that's interesting. Somebody was trying to get the defense counsel disqualified, and there's communications about it. Is that what that looks like to me? To you guys? That's what that looks like to me. Where are we? Documentation of the relationship between Baudet, Fortson, and Cohen. Baudet sending defense work product to McLeland. So somebody sending defense work product to the prosecutor. Remember that ex parte motion they weren't supposed to have? Who gave it to them? They weren't supposed to have it. All right, so Baudet posting regarding sending information to McLeland. Baudet identifying source in Delphi investigation. Oh, shit. All right. Yeah, so I skipped one. Yeah, Baudet identifying source in Delphi investigation. So there's a communication out there somewhere of this person, Baudet, Gary Baudet, Fig, whatever, identifying the source in a Delphi investigation. Baudet's posting sending information to McLeland. Baudet posting regarding digging dirt on Baldwin. Baudette posting regarding working with law enforcement and prosecution. So, yeah, that's a problem when law enforcement and prosecution are working together to take someone down. Baudette email of McClelland asking Baudette to delete everything. So wait, hold on. McClelland, Baudette email of McClelland asking Baudette to delete everything. So Nicholas McClelland, the district attorney who is prosecuting the Delphi case, told this person, Baudette, delete all these communications. That's interesting. Barbara McDonald on Court TV with leaked investigation information. McClelland email to defense regarding Professor Turco's report. A leaked search warrant affidavit prior to unsealing. 20 Sergeant Holman communications with 20. This is, sorry, number 20 exhibit. Holman communications with Terry Williams and or Secret Keeper. YouTube Frank Meister and Sleuth video. YouTube The Inquisitor True Crime claiming leaked communications from Rick Allen. Terry Williams posting about inside information of crime scene and of the investigation. October 22nd, 2022. YouTube video of Baudette discussing his knowledge of a bullet at crime scene and knowledge of a gun was found at Rick Allen's house when that information was still under seal and a week before it was unsealed. So why are you talking about it if it's supposed to be sealed? Email exchange between Judge Gull and attorney Rosie regarding accidentally misdirected email. Baldwin email to Judge Gull. A list of media dissemination by state actors. And Julie Melvin documents and a YouTube video titled A Reckoning in Carroll County. So those are the potential exhibits. Potential exhibits. On or about February 29th, 2024 and March 1st, 2024, the defense received an anonymous call from a woman in Texas claiming to have approximately 240 pages of leaked documents and agreed to provide them. The defense has received only a few of those documents, all of which appear to be available to the public. The defense also discovered information from the prof, like the professor, claiming that he had delivered, quote, 2 pounds of documents to the Indiana Attorney General. The defense is continuing to investigate the claim that which may result in additional exhibits. So they may have some more exhibits if they find out more information regarding this. So they're using a lot of like YouTube sources and videos and online sleuths and people like that, it appears. So that was their witness and exhibit list. Let me go grab my dogs real quick. I just gotta open the door. So hold on 1 second. I'm not even gonna put the thing on. All right. Sorry, never mind. My dogs, it's a nice day. It's a nice day, and they didn't want to come in. So, one of them did. Dexter always comes in with me. He's like, I don't care for outside. I just want to sleep. Sleep on his comfy spot on the couch that he loves. The other two are like, ooh, outdoors, and it's sunny, and it's not freezing, so whatever. But now she's barking, so that's irritating. I can hear him, but you guys probably can't. That's too far outside. All right, now I gotta get my laptop back. Sorry, guys. Here we go. Okay. It's a chore. Getting it all ready. Here we go. All right, so the next document that we're going to do is the state's motion to withdraw, motion for leave of court to subpoena third-party records. So that filing that we just read, the very first filing that we read, it's now March 8th, which is what, Friday? So they submitted their filing on a Wednesday, and now Friday they're saying, we're going to withdraw that, Judge. Sorry. So, ex parte. The meaning of ex parte, literally from Latin, means from one party. So an ex parte motion is a court filing that is only available to the attorneys of record for the filing party. So if Richard Allen's attorneys file something ex parte, it's only available to them and the court. Opposing parties are restricted from looking at it. So this genius, Nicholas McClelland, literally quoted from a document that is an ex parte document that he should have never had his eyes on. So, with that, we're going to move on to Alexa off. Alexa.
That's enough.
Sorry. I have like a trigger thing on Alexa, so she starts to she yells at the dogs and she plays like coyote howls and some stuff when to like get the dog's attention when they're barking, and she can hear them outside, but I don't think it's that loud that you guys can hear it. It's just she can hear it. Anyways, so we've got, this was filed the 8th of this month, March. The state, this is the state's motion to withdraw the first motion that we just read. So I apologize for, you know what, I'm going to zoom in a little bit. I apologize for the way it looks. It's just that I had to grab an image of it, a picture of it, so it's kind of blurry. So here we go. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland, and respectfully ask the court to withdraw the state's motion for leave of court to subpoena third-party records filed March 6, 2024, and in support of said motion would state the following: that the state received the verified ex parte motion for hearing on funding for expert services filed by the defense on February 26, 2024. That the state's access to said motion was not denied in any way. So it's not our fault. Even though it said ex parte, it's not our fault. The state believed it to be a document that was filed publicly. My dogs are going crazy. I don't know what is going on out there. My neighbors got somebody over or something. All right, so that prior ex parte filing by the defense filed on December 8th, 2022, June 6th, 2023, and June 16th, 2023, all were filed publicly and all were accessible by the state and anyone else involved in the case. Well, that shouldn't have been. All the prior ex parte motions filed by defense were captioned like the current ex parte motion that was filed. The state did not know and had no reason to believe that the filing was private because the state and any other attorney who is on the case had access to the filing. That if the state wanted it sealed and wanted the state to not have access, it should have been filed in the appropriate manner. That the state was notified by the defense on March 7th, 2024 via email addressed to the judge that the filing should have been sealed and that the state should not have been given access. And 9, Knowing that it is not intended for the state to have access to said filing, the state now withdraws its motion for leave of court to subpoena third-party filings filed March 6th. So now that we know, we're not supposed to have access to any of these ex parte motions, because even though we're lawyers and we're supposed to know what ex parte means, we read them anyways. We were going to withdraw our motion to get his mental health records. Basically what that means there. So then the next motion I have is, what is it? State's notice of submission of witness exhibit list to the defense. So this is just basically Nick McClelland saying, comes now the state of Indiana by its prosecuting attorney, Nicholas McClelland, and respectfully notifies the court and the state that the state has turned over an exhibit/witness list to the defense outlining the witnesses the state may call and the exhibits the state may use at trial. So he's just basically saying, look, we handed over our exhibits to and our witnesses as you made them deliver or hand over to us. So we're just saying we did it too. This is just a receipt of that. And now, motion for an early trial. This was done, so we got a couple other like little small ones here. Motion for an early trial. This was filed on Wednesday also of last week. Basically, all we know is that there was a motion for early trial. We don't actually have the motion right now, or at least I wasn't able to get access to it. But according to Indiana court rules, it's a requirement for a trial for a defendant held in jail on pending charges. A trial must be commenced no later than 70 calendar days from the date of the filing. So this is a Indiana court rule. They have the right to request an early trial, and that is what he did. So this new motion requires that Judge Gall set a trial date no later than May 5th. And that is not an option. She can't do anything to change that. That has to be done. This is a constitutional right of his that he has to get his trial within 70 days of this motion. So there's that. She zoomed in here. Wait a minute. How did I get here? Is this the right one? Oh. Somehow I skipped. I don't know where I am. Hold on. I hate this like scrolly rolly thing. It always changes my page for me. We read all this. Okay. List of additional witnesses. We read that. We read these. Sorry. I don't know how it got here. It just like skipped to earlier on in this document. All right. Sorry. Here we are. Okay. So she has got to give him this trial within 70 days. I'm sorry. I'm all off track now. So within 70 days, it is a requirement. It is his right to have his trial within 70 days. So the next page after that I was trying to get to here is the Indiana Rules of Criminal Procedure. It says literally on the website, adopted effective January 1st, 2024. So I don't know if it was adopted / effective, whatever. Maybe typo. Anyways, so this is under the speedy trial requirements and remedies. A defendant held in jail on a pending charge may move for an early trial. If such motion is filed, a trial must be commenced no later than 70 calendar days from the date of such motion, except as follows. So these are the only exceptions that Judge Gull could not comply with his 70-day request. Number one, delays due to congestion of the court calendar or um, emergencies are excluded from the 70-day calculation. Two, the defendant who moved for early trial is released from jail before the expiration of the 70-day period, which that's not going to happen. Or three, an act of the defendant delays the trial. So if his attorneys were to put in a motion that might delay the trial or something along those lines, then, or, yeah, basically. So if his attorneys put in some kind of motion that might delay the proceedings, then she could deny it. But as it is, I mean, there's no reason for her to deny it now. If a defendant is held beyond the time limit of this section and moves for dismissal, the criminal charge against the defendant must be dismissed. So if he's held in there, that literally means if he's held in there longer than his 70 days and she doesn't give him his trial, you have to dismiss his charges. And that's what that means. All right, so that was the last of all of the filings from last week, the week of March 4th through the 8th. Really, it was the 6th through the 8th because those were the only days that filings came out. So, let me shrink that. If you guys have a real true crime encounter that you would like to share, if you have a case of you or someone you know was wrongfully convicted or wrongfully accused of a crime, or if you just have suggestions of other topics that I could cover on my channel, please feel free to write me at crimeandcourtchannel@gmail.com and let me know your true crime story, your story of being wrongfully accused, wrongfully convicted, whatever it may be, or just suggestions on other cases that you would like me to cover. Let me know in the comments below. Thank you so much for watching. I really appreciate you. I appreciate your views, your likes, your comments, and your subscribes. Thank you so much, and I will see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeandcourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.